Welcome. I'm Jennifer Brown, the Dean of the Law School, and I'm very pleased that you all are here to listen to these two papers and to be with us for this, which I think is the fourth in the series of student workshops, our emerging scholars, and this opportunity that we have to showcase our students' work, which is, I think, a very important part of what we do here. I sometimes think about the final bench for moot court or the final bench for mock trial as a great opportunity for the community to get together and congratulate people for all the hard work and to see the product of their labors. And this is a very similar kind of thing for these students who have worked so hard on their research and writing to produce this scholarship and the new knowledge. So welcome everyone, and congratulations to Tyler and to Megan for your work today. Thanks.
I'm going to do a teeny tiny little introduction, unless you were.
No, please go ahead.
Okay. So Tyler will do a little presentation on his note, and our commentators today are Professor Mickeljohn, whom you all know, and Michael Clear, whom I think a lot of you also know, is a partner at Wigan and Dana in the firm's private client services department. He is co-chair of the probate and estate section of the Fairfield County Bar Association, a member of the board of directors of the Connecticut chapter of the Exit Planning Exchange, and a graduate of the Quinnipiac University School of Law, where he was the executive managing editor of the Probate Law Journal. So welcome back. Thank you.
All right. Well, thank you for coming tonight. Subject of my note, or the title of my note, is Simplify the Process, Why Connecticut Should Adopt the Use of Transfer on Death Deeds. I have the first slide. I sort of wanted to just start out by explaining why I chose this topic, and sort of what interested me in researching and writing about this. During my 2L year, I had the opportunity to, in the first semester, take a legislation course, which was then followed up as the second half of that was doing an internship up at the state capitol in Hartford. My particular placement up there was with the Legislative Commissioner's Office, which basically are just the staff attorneys who do all the bill drafting for each of the different committees up at the state capitol. So there's one attorney assigned to each committee. I had the opportunity to work with just about every attorney in the office in some way, but I primarily worked with two attorneys who did energy, and then the other attorney did education. So not relevant to this, but it gave me a lot of experience in bill drafting. We're having a little problem with that, but and so once I got the experience in bill drafting and working in that field, I wanted to try and find something a way to incorporate that into my note and make that a part of my research here. But I didn't want to just write about any bill or any draft or anything like that. I wanted to find something that I did have a true interest in within the probate field. And one of my interests was real estate law. I've had the pleasure of taking Mickeljohn's course, the real estate transactions course here at the law school. And I've also had the opportunity to intern for a firm in Cheshire, Bailey and Hirschman, which is one of the more prominent residential real estate firms. I've worked there over the summer, and I'm still working there this semester. So it's given me a lot of good experience on the practical side of real estate and how closings are operated and that sort of thing. So basically what that led me to was finding the Uniform Real Property Transfer on Death Deed Act, which was a uniform act that was proposed in 2000 or drafted in 2009. Since that time, about 24 states have taken the Uniform Act and adopted that into their state laws in some way with some minor changes, but most states have essentially adopted the act as it was released from the Uniform Law Commission. So basically, I took a look at the Uniform Act and sort of did an analysis of what exactly transfer on death deeds were, what the effect of them were, and why I think it would be a good thing for Connecticut to adopt such a law. So basically, just to give you a brief overview of what exactly a transfer on death deed is, very similar to a typical deed that you would use to purchase a piece of property. Most states that I've seen the examples of that have it, it's a very simple one-page document, includes a lot of the same formalities that you'd find in a typical warranty deed or something similar. It has to just name the grantor and the beneficiaries, have a legal description of the property that's being conveyed, has to have a signature by the grantor and have it be acknowledged. So that's the first main element of a transfer on death deed. The second one is really what differentiates a transfer on death deed and differentiates it from other types of deeds, is that it must contain a statement that the transfer will take place upon the grantor's death. So that's going to sort of apply to the third step where you record it on the land records. Even though you're recording it, it's not taking effect right away. It's not until, as I'll discuss later, the beneficiary puts the town on notice, or town or county on notice, by recording a death certificate, which would then put the transfer on death deed into act and transfer the property over to the beneficiary. Just looking at a couple of the benefits to the grantor of using a transfer on death deed, one of the main benefits that I found in my research was that there's no requirement that the grantor give notice, get acceptance, or deliver the deed to the beneficiary. This is strictly Grantor's Act. They can do this on their own, make anybody they choose to be the beneficiary or beneficiaries, and they don't have to give any notice. I'll discuss a little bit later on why that could also be a negative. There's some downfall to that, which I'll get into a little bit later on. But regardless, the main appeal of this is that beneficiaries don't really have the ability to influence somebody transferring property or not transferring property to them. And a lot of what I found in my research too was that this was a way, the reason a lot of states were adopting this was sort of an alternative to older adults who were adding on children as joint tenants with rights of survivorship to their property, which would then sort of subject them to any possible judgments, and the beneficiary would have interest in the property that could be attached in a judgment, a divorce, any sort of thing like that. So there's some risk involved with the grantor or the homeowner simply putting their child or somebody like a relative or somebody like that as a joint tenant on their property, as opposed to this where the beneficiary doesn't have any rights until they take the property at the death of the grantor. The main benefit, which I focused on a lot in my paper, was that this document is revocable at any time before the grantor's death. So they can, fill this document out and give it to a particular beneficiary. If life circumstances change over the course of time, they can simply revoke this document, which can be done by a subsequent transfer on death deed, which would revoke by inconsistency. It can be an outright clear document of revocation, simply stating they're revoking the previous transfer on death deed, or inter vivos deed that would state clearly in there that it's overriding the transfer on death deed and transferring the property to the person purchasing at that time. There was a couple of notes of caution that they talked about in the Uniform Act, and some of the discussions that I had researched was for people to be aware if there's a couple or multiple grantors that are doing a transfer on death deed, revocation has to be by each grantor. If it's a married couple doing it, a husband cannot simply revoke and then have revocation applied to the wife. They both do have to revoke in whatever way they choose to do so. And it cannot be done by physical act, as seems obvious. Once you record it on the land record, you can't simply go home and rip it up and expect that you've revoked it, because that's still going to show up on the land record, and anybody who subsequently searches the land record will believe that that document is still valid. So what happens with the effect of a transfer on death deed sort of during the life of the grantor is that the transfer doesn't occur until all the grantors have died. So in a similar situation to what I just discussed with multiple grantors, a spouse would be protected. So if a husband and wife did it, transfer on death deed to a particular beneficiary, and one of the grantors dies, that does not yet convey the property to the beneficiary. You have to wait for all of the grantors to die, however many that may be.
Sure. Can I just ask you a question on that? What happens if one grantor dies, but another grantor decides that they want to revoke the transfer on death deed?
I believe, from what I understand of the laws so far, they would be able to revoke, I believe, the entire transfer on death deed grant to that beneficiary, and they can choose a new beneficiary. So it still does provide the remaining grantor the ability to adjust the transfer on death deed to a new beneficiary if they feel that the old beneficiary is no longer worthy of getting the property.
So that could result in frustrating the intent of the grantor who died first?
There is a little bit, yeah, there is a possibility for that. I think it's something relatively new. Like I said, the Uniform Act was just in 2009. A lot of states have just been recently adopting it, especially within the last year or two. I think it's one of those things that's going to certainly adjust over time once it sort of gets out into practice and a few people start using it, and lawmakers and attorneys have the chance to see what type of situations arise, like what you just mentioned, and how the law might need to be amended based on that. And I specifically wanted to highlight Section 12 of the Uniform Act, which I include in my paper more in depth. It does go into specifically what rights the transfer on death deed does not affect during the life of the grantor. It doesn't change anything with the grantor's rights. They're still the property owner. Nothing has changed there. As I mentioned, the beneficiary acquires no rights until the death. And another one I wanted to highlight was that it does not affect any of the grantor's creditors. It doesn't affect their rights, which is very important because, as most people do, they have their home mortgage on their home, which the creditors will have a right to in the case of foreclosure or anything like that. Okay. So once the grantor dies, like I said before, they can simply go to the land records. Most states have adopted the Uniform Act, which they suggested was the method of simply recording a death certificate on the land records, which would then put anybody on notice that they have taken property under the previously recorded transfer on death deed. The thing that I found interesting about this was, and this is what I mentioned earlier, where although you're not required to put the beneficiary on notice, I think that as long as you don't think it's going to be detrimental, it may be good to put the beneficiary on notice that they are entitled to this property under the transfer on death deed, because the Uniform Act and the laws in a lot of the states that have adopted it does say that the beneficiary takes the property subject to any conveyances, encumbrances, assignments, contracts, mortgage liens, any other interest that the grantor has on the property. So if the property is heavily encumbered, I saw that as the beneficiary is going to need to evaluate how they take this property. If they simply are overwhelmed by it and have no interest, they could disclaim the interest altogether, which is a possibility under this law. Or they could be the difference between them deciding to keep it as a principal residence and maintain ownership, or simply looking to sell the property right away, hopefully to pay off all the outstanding debts on the property. So some of the benefits of using a transfer on death deed, I apologize for the technology, but one of the major benefits highlighted, which as we spoke could be a little bit controversial, is that the beneficiary gets a step up in his tax basis once they take the property. So it's considered that the transfer obviously would occur at the time of the grantor's death, and that's when the beneficiary would take the property. So the beneficiary would get the benefit of the value at the time that the grantor has died and they take the property. Obviously, this could be a significant amount of money, depending on how long the grantor has owned the home and how much they purchased it for. If this is a home that the grantor has owned for 20, 25 years, they may have bought it for a small sum of money, and it now could be worth a couple $100,000. And the step up could be pretty significant in that case. Another obviously benefit that I mentioned before is sort of the benefit of avoiding the possibility of adding your child on as a joint tenant with rights of survivorship. As I mentioned, that you just want to avoid the possibility of the beneficiary sort of taking advantage of the rights that they acquire when they're put on as a joint tenant, and possibly taking advantage of the grantor and putting them in a detrimental situation while the grantor is still relying on that property as their home. A couple of the concerns that a lot of people have raised in the states that have started to adopt transfer on death deeds, and other states that have considered the law but not adopted it, is as much as it's a benefit that the grantor can revoke at any point, there also could be a downside to that, in that the grantor is the only person capable of revoking this. Obviously, if a situation comes up where the grantor becomes incapacitated, then the transfer on death deed is essentially locked in, and whoever the beneficiary is at that time, if the grantor never becomes capable again of revoking, then and they wish later on to change the beneficiary, they may not be able to if the grantor is incapacitated. And then the other thing that has come up is that certain states have made grantors ineligible for Medicaid benefits, because what they have considered is that although the idea of the law is that the transfer does not occur until the death of the grantor, once they say that you create the transfer on death deed, they're considering that a transfer at that time, and they're saying that because of that asset transfer, they would not be eligible for Medicaid benefits. Specifically, Colorado has drafted this into their laws, and they specifically said if you do a transfer on death deed, there's no question you are absolutely ineligible for Medicaid. So again, like the situation that I raised, if somebody becomes incapacitated or needs significant Medicaid help later in their life, but may be unable to revoke depending on their capacity at the time, this could create an issue. One possibility I thought of for solving this problem would be for the grantor or grantors to execute a durable power of attorney at the time they do the transfer on death. This was something that certain states that have adopted the law, such as Washington, have amended their laws regarding the durable power of attorney to say that you can provide somebody else a power of attorney with the power to revoke a transfer on death deed as long as you explicitly state it in the document for the power of attorney. So, if Connecticut were to consider this law and consider adopting it, they may also have to look at some complementary laws like the power of attorney laws to possibly add that section in so that everything complies and the grantors have options in case certain situations like incapacity might come up later in their life. I'm sorry, yes.
Before you move out of that slide.
Sure.
Would it be possible for the trustee of the trust to be the grantor in this kind of situation, or does it have to be? In other words, can I convey my property to my trust and then the trustee then has the power to execute this deed or not?
In my research, I did not find anybody who used the transfer on death deed in that capacity. Like I said, it's relatively new. I did attempt to research to get an idea of who might be using these the most and what type of people does this benefit the most. But there really isn't a lot out there yet in terms of statistics or data on who is using it, if it's in a trust capacity or if it is just individual grantors who learn of the law and want to take advantage of it. I think that might be something that comes out more over time. So it may be possible for a trustee, and again, that might be something that state legislatures need to address once they decide to adopt this
So I
law.
guess if you're setting up a trust, you don't need this.
That's possible too. Finally, there was a couple of relevant complementary laws that I sort of discussed in my paper that came up in a lot of states and with the Uniform Act that states at least want to take a look at and make sure that their laws are cohesive with adopting a Transfer on Death Deed Act. Would be the anti-lapse law. You have to at least consider whether or not if a beneficiary does predecease the grantor, if how your anti-lapse laws in that particular state may affect what happens to the property then, if it falls to the beneficiaries or if it falls into intestacy. Obviously, that can have a big effect on where the property goes and whether or not that's complying with the intentions of the grantor. Revocation by homicide, I thought this was relatively self-explanatory for this case since the property transfers on death. You certainly don't want to incentivize anything, so you want to make sure revocation by homicide, your laws in your state are very clear that you cannot get rid of the grantor to say and make sure that the property transfers to you sooner rather than later. And then the simultaneous death statutes, obviously that can have an effect based on the fact that this is a at death transfer. You just need to be clear as to what happens in a situation where a grantor and a beneficiary may die simultaneously or in close time with each other. What's going to happen with the transfer on death deed in that situation. And the final part of my paper was my recommendation. I did something a little bit different than I think what most typical notes do for a recommendation section. Typically, that's kind of your summation where you give your opinion on all the research that you just discussed and all the research you did. I did something a little bit different where I decided to take a look at it and say, if Connecticut was going to adopt this, what should the law look like? So I drafted the bill myself. I didn't include anything on the PowerPoint because it's a little bit lengthy. It's a couple pages long. But based on my experience with the Legislative Commissioner's Office and taking the course in legislation, I I had a very little bit of experience drafting bills, and I sort of wanted to take on the challenge of drafting something more substantial myself. So I took on that challenge, and I was happy with how it came out. And I don't know if Connecticut did consider this back in 2013. The Judiciary Committee did take a look at it. They had a public hearing on the bill. But after the public hearing, it didn't make it out of the committee at that point. I did speak at my time with LCO with the attorney who represents the Judiciary Committee and who had done some work, some research and some drafting of the potential bill. And I asked him specifically what happened to this bill and why it didn't proceed in 2013. And he said, really that year, just the legislators on the Judiciary Committee weren't very educated on it. It was something relatively new. They hadn't had a lot of time to learn what exactly they were discussing here. And it sort of just got passed up by more pressing matters that they were more interested in pursuing.
I think Representative O'Neill has put it back on the table. I looked through the judiciary bills yesterday, and I think I remember seeing that.
So maybe coming back up this year. Thank you. But so it's something that may be coming up again this year, and I certainly don't expect my draft to be the one considered, but I hope I did a respectable job. And again, if anybody does wish to take a look at any part of the note, and in particular the section that I did where I drafted the bill, you can certainly contact me or anybody with the probate journal. We can get you a copy of the issue that's coming out, I believe, in the next week or so, and that'll have my full note in it, including the draft of the bill that I did. That's it. Thank you.
So you talked briefly about who you thought would like it. Who won't like it?
I think in terms of who won't like it, I think it's going to depend on how much exposure this really gets. I think there's a certain amount of education that needs to take place here. In my research and my thinking of drafting the note this was just providing what I thought was a good alternative to elderly people, particularly later in life when they might be looking for some assistance in any kind from their adult children, and that's the type of situation where they may add on a child as a joint tenant or something like that. In terms of who won't like it, I think there are some flaws in it where I think there needs to be some stuff worked out where I think there could be some changes in terms of the process of how it's done on the land records. I think that can be a little bit confusing. I think, title companies and people who deal in real estate on a regular basis might have some input on this, because I think the fact that you could have a transfer on death deed recorded, say this year, the grantor may not die for another 20 years, and then simply having a death certificate recorded, that could cause, I think, a little bit of confusion on the land records. So I know that was one thing that I found during my study of it was I think there could be more discussion, more thought into possibly how you handle the recording of it and sort of how it's dealt with on the land records.
Because I know in thinking about it, I was thinking who wouldn't like it, and I have to imagine actually creditors aren't going to like it. Attorneys aren't going to like it. To an extent, funeral homes might not like it, and why? It's because you make an easy transfer at death of if the intended population of people, let's say, who aren't going to have a Connecticut estate tax problem, so estates under $2 million, and you're trying to facilitate the probate process, probate avoidance. One of the things that probate protects are creditors. And having sufficient funds to pay off somebody's debts. The mortgage is easy, right? Because the mortgage stays on. Mm-hmm. But if you could maybe talk about, and I think this might go to one of your questions, so sorry.
No, that's all right.
If you could talk about what you think the process will be on when there aren't enough liquid assets in the estate, and you have more claims, plus this property or other property that is.
I think this was. So sorry. This might have been something we talked about a little bit, Professor, where I think there still is the possibility, if there isn't enough assets for the estate to cover the debts, I think there is still the possibility that a creditor could attach a lien to the property, as long as the property has enough value to cover whatever portion of that it might be. So So I think that process might still, all this, although one of the primary goals of this is to sort of take you out of probate, there is that possibility that the probate side could still be involved with attaching a lien to the property and sort of satisfying their debts through that way.
But if I could just pick up on that, as I read your statute, let's say you have a $300,000 estate and $400,000 worth of debts. The debts are not paid pro rata from all of the assets, probate and non-probate. They're paid, $300,000 of the $400,000 in debts would be paid from the estate, and only $100,000 from the property that goes under the deed. Why favor the beneficiary under the deed over the beneficiaries under the will or under an intestacy?
I think it may depend on that particular situation and how many beneficiaries they are handling it on both the deed side and the probate side. And I haven't seen specifically the states that have adopted this really deal with this issue, and that's something I think when we had this discussion about this, I think it's something that certainly needs to be addressed, is how would the division of that debt, that lien, be handled, because there is a possibility for one side to benefit a lot more than the other. So I think that's why I found this to be a good sort of basis of a law and a good idea in general, but I think there's a lot more that goes into it, and that might be part of the process of the reason the legislature in Connecticut is taking a couple of years to consider this possibility, is I think there's a lot that goes into amending other laws or making sure it complies with other laws to sort of address all the situations. And I think it's something that is still developing, because I've had a very hard time. I really didn't find any current litigation that involved transfer on death deeds where they might have been able to sort of weed out some of the issues that might come up with the use of these. So I think as the years go on, especially in the states that adopted it much more at the beginning, about 5 or 6 years ago, I think they might see a little bit more litigation of people starting to pick out some of these issues like you've raised, and we might start to see more clarity in how those sort of issues might be handled with this law.
On the one of those issues, I think is especially in Connecticut, is the elective share for the surviving spouse. There's I always mess in my head. I mix the statutes for elective share and intestacy, but either way, it's based on the probate estate. So it's an easy way for a bad spouse to knock out the other spouse. Maybe not their bad spouse, but the spouse acting to knock out the other spouse in Connecticut. So I think you'd pointed that out, but it's one of those things in Connecticut that will cause problems, at least in drafting.
I think there are absolutely, there is, I think, like with any law, there is certainly downsides and concerns there. I think it's just a matter of how much that's being taken advantage of, and obviously if this is that becomes something where bad spouses are taking advantage of it way too much, that I'm sure it's something that this law would be, handled down the road if that were to come up.
Why should the holder of a durable power of attorney be able to revoke one of these deeds? I think you told me the holder of a durable power cannot revoke a will.
Yes.
So if you've got an incompetent principal and the holder of a durable power of attorney, that attorney in fact can revoke the transfer on death deed even though he or she cannot revoke the person's will. And I just wondered why the difference in treatment.
I think where I kind of looked at it was, they cannot revoke a will, which, obviously you want to maintain what the testator's intentions were with creating the will. But I did find that a lot of the states that currently have the law do allow durable power of attorneys to have some control over transfer on death deeds. Like I said, if it's specifically stated in the power of attorney document. And the way I looked at it too was that if you created a trust, which is sort of another alternative to doing something like this, you're going to give a trustee certain power over your assets and the power to make pretty significant decisions similar to something like this over a trust. So I think if you're going to be able to to delegate power in that sense, I don't think it's too far of a stretch as long as the grantors in this case are, overtly aware of what they're granting, what power they're granting. And I think that goes into part of this, I think, suggested law is that it's, so simple a grantor could simply grab the form document offline and do it themselves, which I think is actually a major flaw in what the Uniform Act, that was one of the major flaws I thought in how they drafted it, was they seem to suggest that was one of the major benefits, where I think that's pretty dangerous to actually suggest, because I think even if the grantor may fill out the document himself and execute it to the best of his knowledge, I think at the very least he needs to at least bring it to an attorney, to have the attorney review it to make sure it's executed properly, and I think to have a conversation with the attorney to make sure they fully understand this law of exactly what are they doing and what the effects are once they do record that on the land record and it becomes a valid document.
So that raises another question, which is whether you think the formalities that are used for deeds are equivalent in terms of the formality, the functions that formalities are generally supposed to serve to will formalities.
I think the formalities of a deed could serve in this case because, the document is intended for the grantor to simply, it's a simple document that the grantor is just able to transfer property. So I think I would keep the keep it similar to a deed in that sense and not require the further requirements of executing a will. Again, obviously there can always be situations where that becomes a little bit dangerous if you don't have witnesses attesting to whatever's going on in the situation. But I do think that the deed requirements would satisfy in this case.
Similar on those lines, I think most powers of attorneys will allow you to change the beneficiary designations. They might be able to, you may be able to change the Taunton Trust kind of final owner. So it is somewhat similar. And at least if it's a fiduciary doing it, you then have a breach of duty action against that person, which is a nice kind of backdrop for more attorney work. Thinking about, the question on joint owners. And just let me see if I got this right. So we own a property together, joint tenants, right, or survivorship. Together, both of us pick a beneficiary?
I think there's a possibility to do sort of both. I think you could, joint owners could pick a singular beneficiary. But I think there's the possibility that you could choose multiple beneficiaries, but
Then I die. He's got the property. He can change it again. So he now owns the whole. He can what he couldn't do when I was living, he can now do now that I'm dead to change the ultimate beneficiary, right?
yeah, that's my understanding of the laws that have been adopted to date. I certainly don't think it's perfect. I don't think that's necessarily the best idea, but
So it's interesting if they were tenants in common,
Right.
right? Because then if I could revoke the whole thing, I could change the designee of his half interest, even though he and I didn't own the property jointly.
it may apply differently, I think, with tenants in common, though, because I think your interests are separate in that case. So I think you may just, if say you and Attorney Clear, owned it as tenants in common, and you drafted a transfer on death deed to me, I think that would be upon your death, it would transfer to me, and then I believe my understanding of it is I would be tenants in common then with Attorney Clear. So I think it would change a bit in that situation if that was the case.
I think one of the great benefits is that getting people not to add children as joint tenants with righteous survivorship to ease the transition of death. The negative there, the reason why we don't want them to do it, because clients will do that, they avoid the probate process. Part of that problem, though, is that they often pick one child, just thinking that, they're just going to manage it. So when they name beneficiaries, do they pull in the terms like per stirpes, or are they going after specific people?
The forms that I've seen are very basic. It's simply been, name of grantor, name of beneficiaries, however many that might be. So I've seen it very basic. I haven't seen the documents in the states that have used it so far. I haven't seen them use that language. But again, I think that goes back to you really should see an attorney, because that's at the point where an attorney might be able to review it and make sure not only that you executed it properly, but say to you, be able to give you a little piece of advice and say, you might want to add this because there could be a detrimental effect, and you might not be doing exactly what you think you're doing by drafting this document.
I guess a related question is, can the grantor determine how the beneficiaries hold the property, whether they're holding it as tenancy common or in joint tenancy?
I have not seen that they have the ability the grantor has the ability to control that in the deed. It seems that they want it to be a very cut and dry, where the grantor is in control until death. At death, once the beneficiary takes it, then they're in control. I don't think I think they want to leave it where the grantor isn't capable of putting too many limits on the beneficiary, because the beneficiary, is taking on a little bit of liability there, where you need to, I think, keep the flexibility that the beneficiary will have then to do with it what they might need to or want to do with the property.
What happens if the grantor enters into a contract of sale? Is that an automatic revocation? And then I got another question. What happens if after the grantor enters a contract of sale, the grantor dies? And then finally, what happens if the grantor enters a contract of sale and the title company misses this deed on the record and a purchaser actually purchases it, and then the grantor?
So to answer your questions, if they did say the revocation, if you do an inter vivos deed of any other kind subsequent to doing the transfer on death deed, that will revoke the transfer on death deed. So that, to answer that part of your question, yes, that if you enter a purchase of sale, you sell your property to anybody else, the transfer on death deed is not an issue at that point once you complete the deed and record that.
Well, what about during the executory period, between the signing of the contract and the closing?
If he dies during that period, I think, from my understanding of it, is up until the inter vivos deed is recorded, I believe the transfer on death deed is still effective. So if you have a situation like that where there's a death in between the contract and the execution and recording of the next deed, I believe the transfer on death deed would still have effect.
Does either the Uniform Act or your draft give a specific period to the beneficiary for disclaiming?
There is disclaimer. There is a section on disclaimer in both the Uniform Act and my draft. There is not a specific period restricting the beneficiary to disclaiming the property. We didn't put it. There was no time limit placed on it. That wasn't something I had considered in drafting it or my research of the Uniform Act. It's certainly something that may come up.
So if the beneficiary doesn't have notice of this, finds out at the point of death, then is that how it's contemplated? And then doesn't know if there are encumbrances or maybe even worse, some kind of environmental problem with the property. Is there some period for due diligence?
Well, at the time the grantor dies, until they record the death certificate, they technically have not taken the property.
But the beneficiary doesn't necessarily know about it during that period.
According to the Uniform Act, that was their suggestion. Their idea is that you don't have to give notice or any sort of idea to the beneficiary once you make this deed. I didn't necessarily agree with that. Unless there's some circumstance where you really don't want to let them know, I couldn't imagine one. I would sort of suggest to someone to give some notice to the beneficiary because of exactly what you talked about. You want them to have the opportunity to evaluate the property, particularly if, unfortunately, they know the grantor is, possibly going to be dying in the near future. They may have time to speak with them and, learn more about the property and what encumbrances might be on the property. So that was somewhere where I differed a little bit from the idea of the Uniform Act in terms of not giving notice or giving notice to the beneficiaries.
Tyler, first, your draft legislation is fantastic. I thought it was really well done. Second, what ideas do you have for addressing this Medicaid problem, transfer of debt?
I think one thing, well, it depends on where the state falls on it, first of all. I mean, Colorado took their clear stance where they absolutely did not want these people who use these deeds eligible for Medicaid. So, in my opinion, it would have to be a discussion that the legislature has. For me, I think once the legislature has the time to discuss that, and if they make a distinct decision, I think I have no issue with doing what Colorado did in drafting an explicit law that says you are or you are not eligible.
I guess I think it might be difficult in practice. By the time that happens, DSS is going to be denying applicants for a little while.
Yeah, and that was one of the significant issues that I think was being dealt with, and Colorado was one of the first states to really jump out in front of it and address that explicitly. But I wouldn't be surprised if a lot of the other states that have it would.
So it really should go sort of hand in hand. We should assume that this is going to be a problem.
From the way it's being applied so far, I think so, yeah. Any other questions?
Well, just a comment, I think it's a very well done paper, Mr. Gablenz, so nice going.
Thank you. Appreciate it. Thank you.